perhaps, my Lord, before we go to that, my Lord, Senior Counsel Ochieng, I forgot to mention my name. I'm also present for this petition.
Yes, thank you.
Thank you. My Lord Njomo, holding brief for Senior Counsel Paul Muite and other advocates in the petition. My Lord, the petition that the matter that was before the Court of Appeal is Civil Appeal number 829 of 2024.
829?
829 of 2024. And my Lord, when we appeared before the Court of Appeal judges, directions were issued that we would abandon the interim application seeking interim orders, so that we could focus on the hearing of the main appeal. The court further directed that that particular appeal would be heard before the end of the previous term, so that our expectations were that we'll get a hearing date on or about before the 18th of December last year. Unfortunately, that did not happen, and the appeal has not been heard. There have been further proceeding in that particular matter, including a ruling that was delivered yesterday as regards the filing of a supplementary record of appeal. The ruling was delivered and the petitioners were allowed to file a supplementary record of appeal, which is deemed to be properly on record, so that there is full compliance from the petitioner and the appellant in that particular matter as regards filing of their documents in the appeal, and it is ready for hearing. So that the position, my Lord, still remains that the appeal has not been heard, and we are expecting to have a hearing date for that particular main appeal, because the petitioners in this case and the appellants before the Court of Appeal have fully complied by filing all their documents before the court. So that in the circumstances, my Lords, our position for the first petitioner would be that if we can take a mention date before your Lordships, move the court appropriately, and the only thing that we are waiting for the Court of Appeal is to give us a date. That would be the position of the petitioner, but I'm sure me and my colleague Mr. Dudley will have something to add.
Not much really, my Lord. Just to say that we can come back towards the end of this term or right at the beginning of the next term, so that we give the Court of Appeal adequate time to consider the issues before it. We are aware some of the matters are coming in, but our position is that since the appeal is jurisdiction, it impacts the court's power to make any other orders in the matter. And so we can come back when the appeal has been heard and the bench has either been cleared or reconstituted. Thank you, Lord.
Happy New Year, Lord Malili.
Happy New Year.
I equally associate myself with the sentiments and submissions made by my young friends. That would be imperative for this court to create time to the Court of Appeal to determine that very substantive issue. Because the issue, if determined in our favor, will have far-reaching effects in the manner in which this court may or may not proceed in the future. So I would also suggest that we take favorable dates, perhaps the next term, or as proposed by my learned friend Mr. Ochieng Dudley, so that we can give the Court of Appeal appropriate time. In the meantime, the other proposal is that any person perhaps who has not responded or who has not amended the petition may be granted that leeway to comply as we await the outcome of the petition. I'm most obliged.
Thank you very much. 586, we filed it was caught up in glitches in the filing system, the 23rd of last year. Actually, when you our application, petition was caught up in the shenanigans that arose.
With your kind permission,
I'm responding to that issue.
I thought we'd just deal with the first matter first on the appeal, then we can deal with 586 after that.
I thought, with respect to the professor, anybody in support or opposing in the line of petitions, so in the first or the second hard copy, they address the judges. Then the respondents then respond. Otherwise, if we then say the first cohort addresses, it will jump over the issue. It's my proposition.
No, I thought, my lord, in fact, 586 is a fresh petition before you, and you're here to give directions. You haven't given directions. I thought, yes.
That would be our next.
Yeah, exactly. So you're coming too fast.
But it implicates my petition. It does implicate. That's why I thought I should have a vote. I will wait. I will hold my process. Thank you.
My lord. Sorry.
My Lord, sorry for coming late. I was in a murder trial. My name is Kipe Mungai. I appear for the 10th. I think it should be up to 41st petitioners, 10 to 41st petitioners. My Lord, we were supposed to amend one of the petitions, but we've not been able to do so because there are certain information that we are seeking from the Office of the Register of Political Parties that we have now obtained. We will be requesting for the extension of the period for the filing of the amended petition to be extended by 21 days. Partly on account that there are certain compliances with the Court of Appeal that we are trying to comply with regard to applications that are in the file. That is all, my lord, for the time being. Extension of, we seek an extension of 21 days.
Your Lordship, for the seventh petitioner, Mr. Wadita Kiragwabita. Yeah, we agree with the position stated by Mr. John and Mr. Achia. Said that in the event that the Court of Appeal delivers its ruling earlier than the next term, just in case the date is given in the next term, then that decision may be brought to the attention of this court, so that then we can reconvene earlier than that date in the next term.
My Lord and my Lady, I believe on behalf of the respondents, it's also not too late to wish you a Happy New Year. That said, my Lord, I think the directions that you gave at the beginning of these proceedings were very clear, that you wanted an update from the Court of Appeal matter, which then should inform how we progress. I would want to confine myself to that specific direction, so that then we deal with it. If there is need to deal with the matter that is before you, we can deal with it separately. Now, for the record, on behalf of the National Assembly, first, we have complied with the directions that the court had given in relation to filing of documents and responses. We have filed our responses in relation to all the matters that are before you. Number two, we are opposed to any application seeking to in any way derail the proceedings that are before you. And I say that for three principal reasons. Number one, these matters were brought before you under certificates of urgency. my lords will recall the long afternoons, the long evenings that we sat because of the urgency. It is our submission that the urgency was on account of the fact that the issues in all those petitions were issues of a public interest nature. If that be the case, my lords and my lady, then it means that the public interest that subsisted then, which necessitated the urgency, subsists today. The petitioners cannot have it both ways. That when it is convenient, they say they are not ready to proceed, when on that occasion they wanted to have you sit into the night. What is good for the goose is good for the gander. We ask that we proceed with these matters. Number two, there is no legal or factual basis that would necessitate any delay or failure to proceed with the matter or all the matters that are before you. And I say that because when we were last before you, counsels appearing for the petitioners did make an application for stay before you. They even made a subsequent application for a Madu Pepper interim injunction. My lords and my lady, if you remember, you rendered yourselves on those two applications, dismissing those applications. Similarly, the matters went to the Court of Appeal, where they made a similar application for stay. They also made an application for interim stay in the matters in the Court of Appeal. Just like you, the Court of Appeal did not find merit in their application and consequently did not grant any stay. What, therefore, would be the legal or factual basis for asking that we stop or we do not proceed with the matter? In our view, there is absolutely none. As earlier indicated, the respondents are very keen to have these matters heard and determined at the earliest possible opportunity. In fact, my lords and my lady, we will go a step further as to even propose that you give directions that parties file the issues in the respective petitions to pave way for an orderly determination of the matters that are before you. My lords and my lady, that would be in relation to the request that we have a temporary stay, or the request that we have a further 21 days, before we can take these matters into proceeding. It should not be lost, and this is in social media, my lords and my lady, we as advocates have been blaming the courts of delays in determination of matters. It cannot be that when it is convenient, we want to now come and orchestrate that delay and in a social media or any other platform seek to blame the court for those delays. The court must rise as to say no to that sort of invitation. In fact, I would go further as to add that this is an attempted forum shopping which the court must decline the invite to deal with. Now, in relation to the request by Malani Senior, Mr. Kibe Mungai for the petitioners for the 21 days, again, we are opposed to that application. We are opposed because it is our position that when a party comes before you, they always have the totality of the case that they seek to have before you. We cannot have a situation where a party would want to litigate by installments, saying, I filed this in the hope that I'll get additional material before this office and that other office. My lords and my lady, we ask that that application asking for 21 days should similarly be dismissed. You are very categorical. You gave us 30 days. Nothing has happened. Nothing has been placed before you, not in the form of a letter seeking any material before any office, including the office of the registrar of political parties. My lords and my lady, this is a court of record. On what basis are you being invited to give or grant that 21 days? In fact, it is our submission that that is also an attempt at delaying this matter. I would just want to finally draw the court's attention to the attempts that have been made by our colleagues, the petitioners, in derailing this matter at each and every turn of events. We should not, on this occasion, allow them to go that direction. We ask, my lord, my lady, that you dismiss that and give directions on how we are going to proceed. I'm most obliged.
My lord, my lady, thank you for the Speaker of the Senate. My lady, my lords, we have filed our responses since October of 2023 in both petitions. We were brought before this court under urgency. We have sat through, I think we are now at over 20 petitions. Most importantly, my lord, this matter keeps morphing. New petitions are being filed every single day. As you can see, there's a new file before you. This matter needs to be resolved and should apply to the respondent equally. Secondly, my lord, the matter in the court of appeal, to date, there is no stay of this proceedings. There is no order in the court of appeal directing you to proceed. This matter being in the public interest, it is not just, it is not fair that it has not been resolved to date. The actions that the Senate and the National Assembly took are still being challenged. We would like this resolved for once and for all as a matter of urgency. My lords, my lady, we are dismayed that the petitioners who have had us sitting here over and over are now asking for us to wait until the end of the term for this matter to proceed. My lords, we are asking you to allow us to proceed to hearing, and we are ready to proceed at the earliest. Thank you, Madam.
If it pleases you, my lords, I appear for the fourth respondent, the Senate of Kenya. And my lord, I wish to add my voice to the submissions by learned friend Eric Gumbo on the need to expeditiously proceed. These petitions, when filed before this court, were filed with urgency. All of them were urgent. When we concluded the applications, the intention was to expedite the hearing of the petitions, save that this court was waiting for the prosecution of the 5-2B application before the Court of Appeal. You have been told this afternoon that the 5-2B application was abandoned, so there is no stay from the Court of Appeal. You have also been told, my lords, that there is a pending appeal and that a record of appeal has been filed before the Court of Appeal awaiting a date. That is not a stay under the Court of Appeal rules. My lord, there are two cohorts, 522 and 565. We have complied. Senate has complied. We have filed grounds of opposition on behalf of third and fourth respondents and filed relevant or necessary replying affidavits. Cohort number, the 586 that came before this court and that has been filed, my lord, by Harrison Kinyanjui, we have equally complied in that one because we had filed affidavits when the matter was before Judge Mamuye, even before this court gave direction, because he had given direction to compliance by the 10th of January. So we have complied equally. My lord, the way forward in these petitions is as follows, my lord. My lord, this court should direct parties who have not complied, because some speak to non-compliance, to within 7 days comply. The other respondents, my lord, should have a corresponding 7 days to comply. My lord, all these three petitions ought to be consolidated for purposes of hearing, and we can come back before you, my Lord, within 14 to 21 days after compliance. So, my Lord, maybe 21 days from today, as the court may direct, so that this petition can be heard and finalized. My Lord, we cannot politicize a judicial process. We cannot come to court for purposes of adjournment every time. That parties who have filed petitions are the ones who are not ready to proceed. My Lord, if the respondents, the petitioners are not willing to prosecute their petitions, let them do two things. My Lord, let them withdraw those petitions or come to court on the date fixed for hearing and say they are not ready.
Mr. Kungu?
Yes, we had one, my lord, my lady, but we cannot speak through. We're taking my agency.
Thank you.
Mr. Gumbo, which issue do you want to address?
My Lord, I think in the interest of time, let me address the issues in a consolidated sense for all of them, because my response is the same for all the issues.
And only you will speak on behalf of the respondents.
Maybe two people.
I will speak. First, I guess.
Just at the risk of the possibility that maybe there could be a respondent who has a different position, but I wanted to first state that on behalf of the National Assembly, we have filed our responses in all the petitions, including 567, 586, and we have equally served them. Now, that notwithstanding, my lords and my ladies, I think it is playing out that there is a possibility that there could be other petitions that may be finding their way to this court. If we say that we want to wait for all those petitions, it is unlikely that we will be able to take off with this matter. My own proposal on behalf of the National Assembly is that the court considers consolidating all these petitions, because the issues are now, where the reason why we had cohort 1, cohort 2, and the subsequent ones was largely on account of the issue of conservatory orders. Would it be possible that we consolidate these matters, maybe give any party who has not responded 7 days to file whatever they want to file? If somebody wants to amend their petition, is it possible that we agree that within those 7 days they should have filed